All right. Well, I've got 2 minutes after the hour, so I want to be respectful of people's time. So we'll go ahead and get started with today's session. Thank you, everyone who's signing on now, and I'm sure we'll have a few people join as we go. Michael Waters. I'm a partner in BLG's Vancouver office. My specialization is in the area of corporate finance. I'm also one of the founders of BLG's Startup and Grow program, and I am delighted to be acting as your moderator for today's session. We hope everyone's keeping safe and healthy out there, and we really appreciate you taking the time to join us today. Today's session is our second installment on the topic of corporate finance. And this session will be focusing on the stages of financing over the life cycle of a company and the key considerations at each stage of financing. This is the sixth session in our Startup and Grow webinar series. And before turning to today's presentation, I wanted to take just a couple minutes to share a bit more information about BLG's Startup and Grow program. BLG is one of Canada's largest law firms. We have over 650 lawyers working in each of Canada's major business centers: Vancouver, Calgary, Toronto, Montreal, and Ottawa. We are a full-service business law firm. We work with some of Canada's largest and most well-known businesses, as well as brand new businesses and everything in between. We appreciate that large law firms can be a little bit intimidating, and the Startup and Grow program was designed in part to provide access to BLG's expertise in a way that is tailored to meet the needs of entrepreneurs, startups, and early-stage businesses. I'll move to the next slide. The Startup and Grow program was designed to provide access to a complete suite of legal solutions for early-stage businesses, including advice in the key areas noted here. So it is an umbrella program. We appreciate early-stage businesses need access to advice across a wide range of areas, and the Startup and Grow program is an umbrella program that provides access to each of the areas that we consider key to early-stage business. I wanted to highlight the strengths of a couple areas. I think we have one of the strongest intellectual property groups in the country, and that combined with one of the strongest business law firms in the country provides a one-stop shop for an early-stage business. So we think this is a really unique combination from BLG. And item 6 in our terms of specialized expertise, given the depth of expertise in the BLG platform, we have specialized expertise in a number of key areas such as autonomous vehicles. Manoj is integrally involved in that program, fintech, biomedical, healthcare, clean energy, and technology, and many other specialized areas as well. To turn to the next slide. We recognize that cash conservation and cost certainty are critically important to early-stage businesses, and we've designed our service offerings within the Startup and Grow program with this in mind. We've devoted significant internal resources to developing robust materials that we can offer on a fixed-fee basis, so a number of our offerings within the program are on a fixed-fee basis to give you cost certainty. And for brand new businesses, we also offer our Startup and Grow package, which incorporates BLG's best thinking across a range of key foundational documents, providing new businesses with a solid foundation for growth and for future fundraising from sophisticated investors. If you go to the next slide, I won't go through it in detail, but this has the elements that are incorporated in our Startup and Grow legal package. And any one of the speakers on today's presentation would be delighted to answer questions if you have questions following this presentation regarding the Startup and Grow program or anything I've shared today. All right, I'll introduce today's speakers. I'm delighted to be joined by two of our fabulous colleagues today. So joined by Melissa Smith, a partner out of our Calgary office, also on our Securities and Capital Markets group, and Manoj Pandit, a partner out of our Toronto office, also within our Securities and Capital Markets group. Welcome, Melissa and Manoj. And before turning it over, we'll just do a quick rundown of our agenda for today. So we'll be looking at, we'll start out with a very quick discussion of some key terms and concepts, a bit of jargon that gets thrown around in this space, just so you sound smart when you're talking in this area. We'll talk about some key terms. From there, the bulk of today's presentation will be walking through an overview of the stages of financing. So we'll look at the stages set out here, which we'll talk about in a bit more detail as we move through. At each stage, we'll be looking at the key considerations, with a focus on the legal consideration, key legal documents, and the key legal risks at each stage of financing. We'll have a section near the end on preparing for financing and attracting potential investors. Then we'll what we've called an overview of a term sheet. We'll essentially show you where to find a term sheet and show you what one looks like to give you a sense of the look and feel of what a term sheet looks like for in our case, a Series A financing. Okay. And I'll say we've gotten a few questions in advance. We'll try to a bit of time for questions at the end. I want to draw people's attention to the Q&A function, which you should have access to through your interface. So if you have questions as we go, by all means, feel free to type in a question in the Q&A function, and we'll either address it as we go if it fits the flow of the presentation, or we'll try to leave a few minutes at the end to address your questions. And for those of you, we received a few questions in advance. We thank you for those, and we'll try to save a few minutes at the end to address those if we don't address them as we go. Okay. I'll go to the next slide, Christy. Okay, so onto the next slide here. As I promised, I'll just talk about a few key terms and concepts that get thrown around in this space, which we'll be talking about as we move through. So first is on share capital, which we'll be talking about at each stage of financing, what type of share instrument is being used on the equity side, and there's also debt as well too. But focusing on the equity side for a moment, I want to talk about the two broad types of share capital. The first type is common shares. Every company must have a common share. A common share has three primary rights: the right to receive dividends if they're declared. So this is how you get money out of a company. If you have earned profit and it's earned at the corporate level, you dividend it or distribute it out to shareholders by way of a dividend. A right to assets of the company if the company is dissolved, so it goes bankrupt, or if it's liquidated. Common shares have a residual right to the assets of the company after all creditors are paid off. And critically important, the right to vote at meetings. So the way a shareholder exercises their governance rights is by electing directors, so they have a voting right. Okay, on to the next slide. So then you'll hear us talking a fair bit about the concept of preferred shares. So you have to have, the company have to have common shares issued, typically to the founders and typically to other folks, and we'll talk about where. You can start playing around with those rights in the terms of preferred shares. So the most obvious way in which this comes to pass is a preferred share to rights on liquidation or in a bankruptcy scenario. So let's say Manoj has started up a new company, and I'm investing $1 million in a company which has been operating for a year, which Manoj has sort of built from his sweat and hard work, and I'm putting in $1 million. And 2 days after I invest my $1 million, Manoj's company goes bankrupt. I've just put in $1 million, and notwithstanding Manoj's hard work, I want to know that I get my money out first. So I might negotiate that if I'm putting money into that business as an investor, I want a preferred right to assets on liquidation. So I get my money back first. So that could be built into a preferred share term. That's one obvious example, but once lawyers got involved, we built it out into sort of 10 or 15 or 20 pages of preferred share rights in favor of investors. So we'll be talking about those as we go, but essentially they provide additional rights in favor of investors, and they can play with some of the rights attributed to common shares. Okay, next slide. Okay, we'll talk, there's two concepts of the public market and the exempt market. So if you're a public company, you've done something which is called filed a prospectus, which is a huge disclosure document. A public company would typically have their shares listed on a publicly trading stock exchange, such as the Toronto Stock Exchange, the New York Stock Exchange. The way you get to that phase is by preparing and filing prospectus and completing what's called your initial public offering of securities. Most early stage technology companies won't be public companies. They won't be traded on exchange. They'll be private companies. And they're issuing securities, they're issuing equity securities, they're doing in what's called the exempt market. And the exempt market is highly regulated and involves a series of exemptions from the prospectus requirement. So to the next slide. So the prospectus requirement is, again, is large, comprehensive disclosure, very expensive disclosure document, including audited financials that would get filed by a company if they want to raise members from the investing public. And our regulators have said if you want to raise money from folks without filing a prospectus, there's only certain, you need to have an exemption. There's only certain classes of folks that are allowed to invest in your company. You can't just take money from everybody because they don't have the protection afforded by a prospectus. So on to the next slide. So what are the exemptions tend to be used by a private early stage technology company? The most common is called the private issuer exemption, which allows a private company, so it's not publicly traded, to issue shares to select groups of people that have some sort of relationship with the company or have so much money that we're not worried about giving them the protections associated with a prospectus. So you can issue shares to your founders, your directors, your officers, members of your family, which has other risks, close personal friends and business associates, your existing security holders, and crucially, a group of folks called accredited investors. Now, accredited investors are folks that either have enough knowledge or enough money that we feel they don't need the protections associated with a prospectus. So throughout the fundraising process, you will hear people talking about raising money from accredited investors. So angel investors, for example, would fit within this camp. Any sophisticated venture capital investors certainly would fit within this camp. So they have the ability to invest under this exemption. I flag this, one, because we'll be talking about some of these terms as we move through today's presentation, and two, just to emphasize, as an early stage, you can't just go out and raise. It's a highly raising money from people is considered risky, and it is highly regulated. So you want to talk to a lawyer before going and taking money into your business. Okay, next slide. A couple other exemptions you'll hear about. There is something called the minimum amount exemption, which only applies to corporations. It doesn't apply to individuals. So if you invest $150,000 as a corporation, there's an exemption for you. I won't go into it in detail, but I'll touch on you'll hear about the crowdfunding, you'll hear about crowdfunding generally. Crowdfunding is codified into Canadian securities law as an exemption from the prospectus requirement, which allows you to take very small amounts of money from lots of people without filing a prospectus. Hasn't caught on as much as folks thought it might, but just to sort of flag, that's how, when you hear about crowdfunding, that's how it fits into the mix of this discussion. Okay, next slide. Okay, with that sort of preamble and some of the key terms, I'll turn it over to Melissa to walk us through what will be the bulk of today's presentation and the various stages of financing. Melissa, over to you.
Great, thanks so much, Mike. And next slide, please, Christy. So we've divided today's presentation sort of into 6 broad categories of capital raising. These are definitely just buckets. Every company is going to have their own path forward, but we think these are sort of the most common I guess, buckets of financing that you'll see. So the very first one we're going to talk about, Manoj will talk about founders. So this isn't where you're raising a lot of money generally. You're issuing shares right at the beginning. You have an idea, you put a company together, you've got your initial founders together, and you're issuing that initial equity for usually nominal money, the idea being this is going to be your sweat equity. These are the people that are going to put their heart and soul into this business. Following that, you have your pre-seed stage. A lot of people refer to this sort of as the bootstrapping stage. So this is you are tapping all your personal resources to raise money for your business. These are your friends, your family, yourself. You might at this point get involved with angel investors or other startups that sort of understand what you're doing and believe in you. This is generally when you're sort of at the idea phase, you're trying to prove out your concept, you're exploring your feasibility, who your market's going to be. So it's pretty early. I don't know if anyone's ever heard the expression, the FFF round, which is friends, families, and founders, or sometimes people say fools at the end there, but this is sort of your resources where you're raising that initial amount of money, which we'll talk about. The next one's the seed stage. So this is where you're talking probably more to angels. You might still have your friends and family involved. You might be looking at micro VCs at this point or crowdfunding. And this is when you're trying to launch your project. You're trying to build your traction until you get to revenue. You're recruiting your team at this point, and you're sort of developing that market. The next round we're going to talk about is the Series A's investors, and this is really your first VC round. Often you're sort of at a break-even or profit stage. This is when you're going to start having a business model. You're developing your key team. You're trying to get your scalable blueprint together. So this is larger money now that we're talking about. It's going to be a lot more sort of serious round. And then that goes into your later stage investors as well, which is the Series B, C, and D. So this is the scaling up, the growth. You're going to have your VCs involved, and as you get into the C and D, you're probably looking at private equity at this point, hedge funds potentially, or investment bankers. And then the idea at this point, especially when you're getting sort of to the C and D, is that you're scaling up for either going public transaction or an exit through, selling your company or something like that. But that's sort of the exit strategy for all your early investors. So we're going to talk about each one in detail, but that's sort of the series and the cycle of business. So I'll turn it over to Manoj to talk about founders.
Okay, thanks, Melissa. So, once the company's incorporated, and the founders will need to take a number of corporate organizational steps. That'll include appointing a board of directors and appointing senior management roles such as the CEO and CTO and CFO. The founders will usually fill those roles and serve as the sole directors of the company. Where there's more than one founder, the founders will also need to determine how to cut up the pie. That's the equity ownership of the company. And that'll be done having regard to the amount of capital that they've each contributed, whether that's money or sweat equity, or even assets such as intellectual property in technology that's the core of the business. Founders might not contribute all of these items, but the share allocation amongst them is likely to reflect their varying contributions to date. In a number of startup scenarios, we see that sweat equity and other intangible contributions are difficult to value. It's a challenge, and often founders divvy up the pie purely as a matter of negotiation based on what they both deem fair to each other and to themselves, and also to make sure that there's adequate incentive to secure each founder's commitment to the new enterprise. So in many situations, founders impose and they accept for themselves vesting provisions on their founder stock in the company. This is, of course, where there's more than one founder. Vesting provisions might be, one or a combination of time-based vesting, so that a number of shares are issued every month, quarter, or year, some period of time during which they're committed to the company, or the vesting might be performance-based, such as the founder having to deliver on certain, predefined code or product development milestones. Founders are strongly advised to put together a shareholders agreement. It doesn't have to be complex at that stage, but it'll have to cover a number of issues. They'll need to anticipate their funding requirements and how much equity and how much control over the company that they'll need to give up as they issue shares in subsequent rounds of financings. So it's important to be flexible in your shareholder agreement. I do differentiate between equity and control, and as we'll see later in this presentation, there's several mechanisms such as common versus preferred shares that Mike alluded to earlier, veto rights for investors, board nomination rights, preemptive rights, and so on. And those will all need to be considered and negotiated with investors. Therefore, it's a good idea to start with a fairly straightforward shareholder agreement that can be amended by the consent of the founders alone, so that these points and issues can be addressed. Yeah, my last point here is, I guess, founders should consider establishing at the inception, so around the time they form the company and issue themselves the shares, they should think about the capital structure to address the whole issue of control. Often we'll see that that capital structure consists of common shares that'll be allocated to the pre-seed and seed investors, which Melissa will talk about in a minute. But there might also be multiple voting common shares allocated to the founders themselves. And multiple voting shares can allow the founders to retain voting control over the company even though and as their equity interests get diluted in subsequent rounds of financing. But those multiple voting shares would have the same economic rights as the regular common shares. So I'll stop right there, and back to you, Melissa.
Great, thank you so much. So just get the next slide. So once the company's set up, you sort of move into this pre-seed stage, and there might be multiple rounds in here or just one, depending sort of how fast you're able to scale up. But if this is a point where you're sort of moving towards your viable product, you need money to develop your product, to hire a team, to look at your market, to get your business plans together. And this is often where you'll see it's a lot of friends and family. It's people you know who you're going to go out and talk to and see if they'll put money in to help you get to this stage. I like on the slide that it's underlined anyone you can legally permitted to invest in your company. And this goes back to what Mike was speaking about at the beginning. You cannot be offering shares at this point to the public. You're a private company. You need a prospectus exemption. So it will be friends and family, accredited investors, other directors, officers, founders that you're able to go out and invest and ask to invest in your company. And the documentation for that is going to be a subscription agreement. So often, you know, this, when you think of a subscription agreement, a lot of people think of sort of a one-page agreement. At this point, because you have a prospectus exemption you need, because it's starting to build your business, it might be a more substantial document than that. So you might be looking at legal at this point. Again, talking about the shareholders agreement, the more shareholders you have, the more you need to worry about people agreeing how things are going to go. You don't want to have minority shareholders that have basically veto rights over your business. So that is also still important. I think this is a stage two where you're kind of working out all your legal documents, your partnership agreements, copyright issues, other IP issues. And so some of your money is going to go to that sort of administrative or professional services as well. Sort of the more common securities, the easiest is probably still common shares. You also might be looking at a convertible debt instrument or a safe. For anyone who's not familiar with safes, they are called a simple agreement for future equity, and it's not a debt instrument. It's basically an agreement that they will purchase equity shares at a later point. The only thing I wanted to bring up about this is a really good tip I've heard from people is when you're in this pre-seed stage, even if you're going to your parents asking for money, it's great to treat this as if you're talking to any investor who might not be your friends or family. So it's good to get your pitch together at this point, to have projections, to practice doing your presentations. It's great practice for future rounds. It's good to get due diligence together, for example, at this point. And it sometimes also helps with the awkwardness of approaching family for money, to sort of treat them like any other investor. And the last thing I'll say, sorry, before turning it over to you, Mike, is angel investors is a group that comes in sometimes at this stage, or other entrepreneurs, and they can be really helpful, not just for the money they're going to bring to your business, but for the experience and advice and mentorship they can bring to your business as well. That's another great group to get involved at the pre-seed stage. And I'll turn it over to you, Mike, for the next one.
Thanks, Melissa. A few questions popping up in the Q&A. Thank you for those. One sort of directly on topic here, Melissa, which maybe I can give to you from Alicia. Is a safe similar to a convertible note?
Yeah, so it's similar to convertible note. I think the important point is it's not debt. So if you have something like a convertible debenture, that is actually a debt instrument. So if you did go bankrupt, for example, debt instruments can be paid out before equity. A safe is simply an agreement to buy equity, so shares at a future date when you do a priced round. So that might be a Series A round. So it itself is not a debt instrument. I think it would be the key difference between sort of a convertible note and a safe.
Thank you. Thanks, Melissa. Yeah, and I think it's one of the traditional rationales for a safe is sort of punting the valuation question that Manoj touched on, which is rightly was noted, is very difficult for early stage investors in terms of figuring out what the company, what valuation is appropriate. So one of the advantages of a safe is it punts off valuation until a later stage of the business, perhaps a Series A, when additional money comes in. Disadvantage of those is that can be a long, uncomfortable period for certain companies. If you're expecting to do a Series A within 6 months or something like that, it's something imminent. a SAFE can work well. If you don't have sort of a clear path to Series A, it can be a pretty uncomfortable period of time between a SAFE investment and doing your Series A if that's going to stretch out over a year or two. So we don't see them as often in Canada as we do maybe in other, down in California, for example, but we do see them from time to time.
I would just throw out, sorry, Mike, if you are looking at SAFEs as well, the other thing that is making sure you understand their conversion features, what percentage they're going to transfer into in the future. You need to be very clear on that, or they can really mess up your sort of cap tables, and you can end up giving away more of your company than you want to. So if anyone's considering a SAFE, I'd say definitely get some advice around that. It's important to really understand how they work on the conversion.
Yeah, completely agree. Thank you, Melissa. And one question I'll touch on, because it sort of goes to the, Melissa noted the concept of a subscription agreement, which is what your investor will sign up with you in order to subscribe for, let's say, common shares, but would also work for preferred shares. One question was, do accredited investors need to provide proof of accreditation? Yes and no. There will be a certificate attached to it. Well, they'll have to indicate which category of accredited investor, and they'll need to certify. They'll need to, so it won't necessarily be proof, but they will need to certify that they are an accredited investor. However, our regulators have made clear that it's not enough just to rely on that certificate. They haven't gone as far as prescribing due diligence, but if you have any reason to believe that the person doesn't meet the test for an accredited investor, the regulators will require you to take additional steps. A short answer is you certainly need a certificate, and you need to be comfortable the person actually meets the category they say they meet in terms of being an accredited investor. Most common categories for individuals, for example, would be income over $200,000 a year or $300,000 with a spouse, or there's also financial asset tests as well. Okay, I'll move on to stage 3, the seed stage. So this stage of financing sort of bridges the gap between pre-seed and doing a Series A, and it can attract. It can at this stage attract institutional investors, but it might attract angel investors or other accredited investors that are willing to cut sort of a bigger check required to sort of move to the next milestone in your business, which can be working towards customer validation of your product once it's been developed. So it sort of gives you a sense of the range of investment in this phase. So these are amounts of money that are typically going beyond sort of your friends and family network. You're into sort of more sophisticated angel investors, potentially institutional investors. In terms of the types of securities used, if it's an institutional investor, and we'll talk about this a little bit more in the next slide, but if it's an institutional investor, they're going to want preferred share protection. An angel investor might be willing to invest in this stage still for common shares, so it can go either way. Similar documentation to pre-seed if it's a common share. If it's a preferred share, it'll be similar documentation to what we'll see in a Series A financing, which we'll talk about in just a minute, and key risks. Valuation concerns, again, still very difficult to set a valuation for a company at this stage. And if you do start to issue preferred shares, the potential for dilution and the preferred share rights issued to your investors. Remember, as a founder, the preferred share rights are the person getting preferred is the investor. So the person on the other side of that who can potentially suffer under those rights is the founder. So you want to be very careful about the types of preferred share rights you're issuing at this stage. And I'll turn it over to Melissa for the next stage. Or pardon me, it's for Manoj, pardon me.
Sure. So we're talking about now Series A. The company has developed its product, defined its target market, and hopefully assembled a core team using the pre-seed and seed offering proceeds. It'll hopefully have an initial user base or customer base and started to generate some recurring revenue. Depending on the sector, Series A rounds are typically, I would actually say, for anywhere between $1 and $15 million. Could be lower in some jurisdictions or markets, but we've seen these rounds go as high as 15, even $20 million in some cases. And typical pre-money valuations range from sort of $10 to $30 million. Typical investors include early stage VCs and some other types of institutional investors, family offices as well, and occasionally even some ultra high net worth individuals. This is probably the hardest round of funding to raise, assuming you're not a serial entrepreneur. And so you should start planning for a Series A around 9 to 12 months before you target closing. That would include 6 months of robust engagement with prospective investors. And it's critical to get your deal terms right for this round because that will set the path for your future funding rounds. Many issues are going to be on the table for negotiation, including the usual tension over pre-money valuation, and also the say that the investor has in the company, including things like veto rights over a number of issues. But equally, and if not more important, is the process that you follow. Many founders don't, actually think about the process before embarking on a fundraise. At this stage, for Series A, the process has to be, well planned and thought out. And as we mentioned earlier, there's sufficient. They have to allocate sufficient lead time for the process. Founders need to develop their strategy for appealing to the venture investors' appetite for, a uniquely innovative company, and hopefully prey on the investors' FOMO, the fear of missing out. That involves a compelling description of how the company is unique and if it's accurate to say so, the prospects of the company to become a dominant player in the space. Some of the key items that you'll need to prepare include a pitch deck and maybe even a memorandum in which you talk about and describe more fully the business and the investment thesis. But I would, sort of give you a word of caution. These documents will likely be caught by the definition of an offering memorandum under our securities laws. And the company and its directors do face liability for, damages for, that might be incurred by the investor for any material misrepresentation in those documents. So it's really important that you run, robust due diligence on these documents and also have them reviewed by your legal counsel and other advisors. I won't say too much about the term sheet because I know that's a point of discussion later on in the presentation. Most founders at the Series A stage don't have experience with term sheets, and they don't know what terms to accept, what terms to negotiate, what terms to push back on. So we'll cover that later in this presentation. And with that, I'll turn it back to you, Melissa, I think.
Perfect. Yeah. Just get the next slide. So we've kind of lumped these later stages together. So Series B, C, D. I mean, in theory, you could have E, F, G as you went along. I would say probably an exit or IPO after D is the most common, but again, every company is going to have sort of their own path. So these are all going to build on your Series A. So as Manoj said, the paper is so important to get right in that first one. These are all going to build on that and will be similar to the Series A. But as I said, there was new priority for the new investors. So this is when you're really growing the company. And in theory, this is as you're getting ready to start going public as an exit strategy if there's not sort of an acquisition that happens before then. So you have a new wave of investors coming in. You're still probably dealing with VCs, but you're going to have late stage VCs coming in now. So these are a little different than the earlier stage ones. They're going to be your go forward sort of investors now getting ready to go public and to help with that phase. They're interested obviously in growth at this point more than, an unproven idea. So very different stage and risk profile for your new investors. As you get into C and D, you're going to be looking at hedge funds, private equity, potentially investment banks coming in as well. You might also be looking at doing a series, I'll say Series D, for example, for a specific transaction now. So you're looking to acquire another company. You need to raise money for the acquisition, but you aren't ready to go public. That might be a reason to do another series at this point. So I think that's sort of all I'll say there, but certainly it's all building on that Series A at this point with this new wave of more sophisticated investors getting in ready for the exit strategy that's going to happen. I'll turn it over to you, Mike, to talk about that.
Perfect, thank you. So we can go to the next slide. We'll talk about exit or initial public offering. So this is really driven by how do your initial sort of early stage shareholders, how do they sell their position, how do they achieve liquidity, how do they earn the return on their shares or their initial stage investments. And there's two primary ways. An exit would be selling the company to another entity, perhaps a larger, well-established entity in the market. So simply selling all the shares, the company would be acquired by the other entity, and shareholders would receive cash or potentially shares of that other entity, but oftentimes simply cash. I would say that is the most common exit, simply being acquired. It's particularly for Canadian companies, just given the scale of the businesses in other jurisdictions, notably south of the border. So there's very large businesses able to acquire sort of businesses that have grown to the stage, particularly in the Canadian market. An initial public offering is slightly different. The initial public offering, we touched on this earlier, would be preparing a large disclosure document, filing a prospectus, and issuing the public on that basis, and then seeking a listing on one of the major stock exchanges. Again, the Toronto Stock Exchange, the New York Stock Exchange. There's been, the advantages of going public historically have been, one, the ability to raise money from a larger pool of investors. You now can raise money from members of the public who aren't accredited investors, who don't fall within one of the other prescribed exemptions. So that it had sort of a capital raising component. The second was creating liquidity for your early stage investors. The trend in the U.S., for some time now has been to use IPO really for creating liquidity for the early stage investors. It's not viewed as a necessary step to raise capital. It has been viewed as a necessary step to create liquidity for your early stage investors. And part of the reason for that is, one, it's very expensive to go public. Two, there's such a robust venture capital private company financing market that has developed, internationally, but particularly in the U.S. So companies in the technology space have been able to stay private much, much longer than we've seen in sort of other industries. So it's certainly more common for companies to stay private longer and to look to an IPO as an opportunity to create liquidity for your early stage investors. I'll note the cost of going public in Canada is quite a bit less than it would be in the US, so it's a bit more of a viable option for Canadian companies to consider a public listing, both in terms of creating liquidity as an exit for your initial investors and for raising additional capital as you can grow your business. Okay, so that takes us to the end of our stages of discussion. This note, this is a rough overview. Not every business will follow each one of these stages. We've seen examples where the founders issue shares to themselves, grow their business, and exit for hundreds of millions of dollars with a very simple capital table. Great, that's fantastic. You don't necessarily need to raise money at each of these stages, but this is sort of a schematic overview of what typical path might be, and at least it gives you a sense of the requirements at each of the different stages. Okay, so with that, we'll go to the next slide and the next sort of broad topic, which we'll cover. I want to leave a bit of time for questions, but we'll very quickly touch on what's required to prepare for financing and attracting investors. And if we go to the next slide, I'll turn it over to talk about due diligence.
Yeah. So due diligence, obviously, as you go through that cycle, becomes critically important when you're looking to try to get a VC or someone to invest in your company. But I would really urge everyone to treat it as critically important right from the beginning. So due diligence is an investor coming in. They're going to look at your minute book. So they want to see your cap table. They want to see your shareholders agreements. They want to see the minutes you've kept of directors meetings. They want to see all your material agreements. They want to know about any litigation. They want to look at your numbers, your books, your financial statements, your tax returns, and sort of any correspondence you've had with regulators. So it's incredibly invasive. And if you're not well organized, it can be incredibly time consuming for the founder team, who's also, trying to get out there, find other investors and run a business at the same time. So really encourage people to think about it right from the start, be as organized as possible. Make sure you're putting stuff in writing right from the beginning as well. They're going to want to do due diligence on your IP. And one of the areas we see a disconnect a lot is people haven't put in written contractor or employment agreements in place. So they haven't included that clause that says everything your employees or your contractors work on belongs to the company and not to them from an intellectual property point of view. And that's the kind of really problematic stuff that if you leave it too long can be incredibly expensive to try to fix if it is fixable. So just really encourage people right from the beginning to be diligent. Make sure you got everything in writing, in written agreements. If your dad writes you a check for $50,000 to get going, make sure it's very clear. Is that a loan? Is that equity? If it's equity, paper it. Make sure you've got the shares out there in the cap table. You just don't want to be spending time when you're trying to raise money, trying to figure out what shares were actually issued or whether or not someone is a contractor or an employee. So just really encourage people to be organized. You can have a data site, you can keep it running and up to date. It's fabulous. And then you just allow investors to come in and look at your data rooms. So I'll maybe leave it there. I could go on about due diligence forever, but just I want to leave it there.
Great.
Okay, so I think I'm up under the heading Matching the Expectations of Investors at Different Stages of Financing. So, founders really need to define their expectations of their investors at each stage. Series A and B, at Series A and B, founders will, of course, be focused mainly on getting the company funded, but they ought to look for more than just the money. They might, especially if they're in sort of that enviable position where they can, procure term sheets from more than one investor or a number of investors. They might consider, the investor's branding, the VC's knowledge and network in the space. Because being associated with a strong VC brand can help with building customer and wider market acceptance. It can also help with recruiting high-value talent, and it might even open doors to partnerships and alliances and building your and your company's wider network. So securing the financial commitment is the hard part, but the more interesting and fun part, you might say, is letting the VC explain to you what intangibles they'll bring to the table in the event that they move forward with an investment. Also remember that it's a long road to travel down with a Series A, a Series A and B, and even possibly a C or D series investor. So make sure you and the investor spend enough time getting to know each other. The investor will have lots of questions about you and your company and your business, but often founders don't know enough about the experience of having that investor sit on their board and what the investor sees as priorities for the company and whether the investor is perfectly aligned with your business plan and your milestones in the way that you interpret them. So that robust conversation is very important. From an investor standpoint, they'll want to have answers to basic questions that almost always come up. So you should be prepared to address things like, what problem are you trying to solve, and what drives the founder team to want to solve it? How well do the founders know the business and its competitors? What is the composition of the founder management team? Is there, more than one founder? Investors prefer to have at least two co-founders, and where there's a substantial technology component to the business, they might prefer that the company have a dedicated CTO, and ideally, one of the co-founders will be the CTO and the other the CEO. Certainly, how realistic is your valuation expectation, and is it in line with other companies in your company's peer group? Ultimately, the investor at any stage will want a sight line to revenue, profitability, growth, and those sorts of things. But ultimately, investors want to be convinced that you have the combination of, talent, a unique product, a ready market, and so on and so forth, in order to drive revenue and hopefully profitability, rapidly. And finally, in this current environment, the investor will need to be satisfied as to how the founders are navigating through the pandemic. And they ideally want to know and be convinced that the founder team's resilience, that the founder team has resilience in dealing with these challenges. Given that the pandemic has hit all sectors and all businesses, and in a few cases in a positive way, it's strongly advisable for founders to ensure that they cover off on this issue in their pitch. That's it.
Great. Thanks, Manoj. I'll just add to a couple of things that have been said so far. First, on the topic of due diligence, all three of us do work on the investor side and on the company side space. So I think the lens we bring is what an investor would want to see down the road. So we do encourage you to talk to legal counsel as early on in the process as possible, and we've got some fantastic resources within the Startup and Grow program to help prepare companies from the get-go to prepare for some of these financings down the road, which can save you a lot of trouble, expense, and a heartache down the road attending to these requirements from day one. And on Manoj's point, I'll simply add that we really have focused on some of the legal requirements, but as Manoj quite rightly, there's an entire business component to this as well. Each of these stages of financing as well too, and obviously the focus of this presentation has been on the legal components, but trying to tie in some of the key business considerations as we move. And then on our last point here, confidentiality and disclosure agreements. I won't say too much here just in the interest of time, but just being mindful. We've got a great presentation on the Startup and Grow website on intellectual property. So critically important if on the intellectual property side of things, if you have any technology that's potentially patentable, that you are sharing any of that information regarding that technology in a way that does not compromise your intellectual property rights. So I think that would be the most important part of it, and I highly recommend our more detailed discussion around intellectual property and under the Insights tab in our Startup and Grow landing page. We've got a great presentation on that, so I won't sort of cover that here. But anytime you're sharing confidential information about your business, you want to be thinking through whether that information is adequately protected. Would absolutely recommend getting in touch with legal to help work through an appropriately drafted confidentiality or non-disclosure agreement before sharing any information about your business, and thinking through a strategy about how you might share that information in a way that protects the business, but also gives your investors what they need in order to make an informed investment decision. Okay, so turning to...
I would just add, Mike, any knowledgeable investor should not balk at signing a confidentiality or NDA agreement. These are incredibly standard. Everyone uses them, so don't ever let people pressure you sort of into giving out information about your business without them. They are really standard documents people should expect.
Thank you. Okay, so with that, we'll very quickly touch on our next topic, which is an overview, a 2-minute overview of a Series A term sheet, which is not enough time to talk about a term sheet in any detail. And Christy, through a feat of technology, is going to attempt to bring one up for us to have a look at. So what we're showing you is the set of documents that have been created by the Canadian Venture Capital Association, the Canadian affiliate of the U.S. National Venture Capital Association, the CVCA, and we're part of the working group that have worked on these documents, have Canadianized a number of the standard form financing documents that have been developed by the NBA in the U.S. So you can, if you search, we'll put the link up shortly, but if you search CVCA model documents, there's some great resources up there. And if you scroll down a little bit, Christy, we just kind of want to give you a sense of what one of these things looks like and point you in directions so you can find one. And scroll a little bit more. So this is, maybe pause here. As Manoj mentioned, this is This is a term sheet prepared for a Series A financing. I think it goes on for about 16 pages, so it's a complex document. Starts out with some of the preliminary matters, such as, and we scroll down a little bit, amounts raised, price per security, and the valuation, pre and post money valuation. The nice thing about this precedent is that it's annotated, so it does have some explanatory notes as you move through. If you scroll down a little bit more, we'll have a capitalization table of your company before and after the business, before the financing event as an exhibit. And then it will go into, in some detail, the share provisions that will then be built into the definitive documents as they're discussed. So things like dividend rights, liquidation preference, and if we continue to scroll through. Scroll down and onto the next page. Voting rights protections, anti-dilution provisions, which are critically important. This precedent sort of sets out a number of examples. A typical volume-weighted version. I believe it has an example of a full ratchet as well too, so you can see what one looks like. If you continue to scroll down, discussing conversion events, and I'll let you continue to scroll. Then goes into the actual share purchase agreement terms. So one of the key documents in a financing would be the share purchase agreement itself, and I'll let you continue to scroll down from here. Then it goes into the terms of the investor rights agreement, and I'll let you continue to scroll. And then the right of first refusal and co-sale agreement, and then into the voting agreement. So each of these sections of the term sheet will be rounded out by a definitive agreement, standing on its own, but this provides a roadmap for those discussions and negotiations. As you'll see, you can have a common share term sheet, which can be 2 pages long. Very, very simple. When you start getting into preferred shares, these are complex documents, and there are serious risks to founders if you get this wrong. So so part of why we're showing this is once you know what one looks like, and have a sense of, if I have a resource you can take a look at, but also sort of to emphasize that these are highly technical, commercial, contractual rights negotiated between the parties, and not something you want to enter into without appropriate legal advice. So that's a quick overview. I'll just quickly pause and ask Melissa if any thoughts on our sample term sheet here.
Yeah, I would just say at a high level, typically term sheets are largely non-binding. They put forward the terms that the investor and the company, agree to in principle, but they're non-binding, except that there's usually a exclusivity and no-shop provision that is binding. That might last for 30 to 45 days, and it'll have words to the effect that the company will not, it'll first of all cease any negotiations with any other investor, and it won't entertain any, negotiations or carry on negotiations with any other investor going forward during that no-shop period. The reason I flag this is because it's important to, before signing this term sheet, recognize that this reflects the business deal. And there will be a whole lot of paper and agreements and documents that will embody all of these terms and conditions. But it's important to understand that this is what you are driving at as your end goal. And while it does happen sometimes that deals don't get done, more often than not, like a substantial majority of the time, once an investor puts a term sheet in front of you, they won't change the terms on you, and they'll do everything in their power to get the deal done, because it's not good for a VC's reputation to see the deal fall apart because maybe they change the goalposts on you. Equally, from your perspective as the founder and the company, you want to get this deal done, because if it doesn't, then you might face questions from other investors as to why this deal didn't get done, and that's not always an elegant elegant question to answer, or there's not always an elegant way of answering that question. So it's in everybody's best interest to get this right.
Yeah.
Great. Okay, Manoj, thanks very much. Okay, Christy, if you take us back to our main slides, and we'll post the links so you have it to the resource we just mentioned here. And if you need a copy of this presentation, you'll be able to find it on our website after the fact. But there's the link to the term sheet we just put up. And we'll now take about 3 minutes to deal with questions from the audience. So we had two in advance that I'd like to touch on quickly. The first was, is it best to get financing after you have a viable company that is making money, or do it at an ideation phase? And I'd like to get the panel's thoughts on this one, but my initial thought on that is, I recognize the earlier in the stage of financing money, the more expensive that capital is going to be, for good reason. It's riskier for the investors. So the more money you take earlier on, the more expensive it will be for you as the founder down the road. However, you'll need to have enough money to actually grow your business. So I don't think there's an answer in terms of the if it's best to get financing in a particular stage, or in terms of when it's making or not, but you'll get a better valuation certainly later on down the road once you have some more metrics you can point to, things like revenue. But I'll ask the group for their thoughts.
No, I agree, Mike, with your answer. That's my thought as well. Important to understand exactly how much money you need to achieve your different milestones, and make sure you have enough. But yeah, definitely more expensive to raise at the beginning.
Okay.
I agree.
All right. Consensus. I like it. Next question I'll pose to Melissa. Shauna sends this question. Thank you. Women are proven to be underfunded when it comes to startups. What steps can be taken to equalize funding?
I think that's a bigger question than maybe I can answer today. But I would say, I think there's a lot of reasons maybe women are underfunded. I remember reading a study probably about 4 years ago now that talked a lot about how investors tended to ask more defensive questions of female-led teams, so more about their track record to date or historical performance, whereas they tended to ask more future-oriented questions of male founder groups. And it mattered because people that give future responses that are more about projections and where it's going and get the story across of what a company can be are more likely to get funding. So I think it's things like that, being aware of that. So I would say this to any founder, but making sure you really know your business. Manoj gave some great examples of questions that investors are going to ask. You need to have those answers down pat. You need to practice, you need to understand, you need to have all that information. I think that might be even more important for women. But then I'd say you also really need to be able to get your story across. So you can't just be focused on past performance. You really need to be future oriented. And I don't know why sometimes that's harder to do for women. I think it is the questions we're asked, frankly. But I don't know if we can change the world necessarily today. Hopefully we can, in a week or two. But I do think also for women, there's a ton of excellent resources out there now because people recognize this is a problem and that a lot of female-led startups are underfunded. So really encourage you to reach out to those resources. People are always happy to chat. I'm involved in a group at BLG called Driven by Women, which deals with women-led business. I've met so many amazing groups and individuals through that process. And just really encourage people to reach out to anyone, but also to these groups that are really focused on providing funding to female startups. I know BDC has a Women in FinTech fund that we've been doing some work with lately that's fabulous. And even if it's not exactly what your business is, I just encourage you to reach out and talk to people. Everyone I've met is incredibly generous with their time and their advice. And, that never hurts to reach out. So those are my tips sort of for now until the world is a bit more of a fair playing field, which I do think people are making a lot of strides towards because this is a problem that a lot of people have recognized. And if anyone on the call wants to shoot me an email, happy to chat always and put you in touch with people I might have met along the path as well who might be able to assist.
That's fantastic. Thank you, Melissa. And with that, maybe I'll ask you to advance it to the next slide. I am mindful of time. We've tried to answer a few of the questions that we've gone through, but I believe we're out of time for today's session. So I'll bring us to a close. Thanks for the questions advanced, and tried to address a few of the questions as we've gone. Thank you very much. I wanted to let you know where to find some additional resources. So as mentioned, we recorded all our past webinar series presentations, and they're available on our Startup and Grow landing page under the Insights tab. So if you search Startup and Grow BLG and look on the Insights tab, you'll find our previous sessions. So as I mentioned, we've got a great one on accessing and protecting your intellectual property. We've got one starting from the very beginning on how to incorporate a new business and some of the early stage considerations for founders. We've got sort of an employment focused one, which deals with hiring practices and key employment law considerations. Also touches on sort of compensating your employees through equity, through stock options or shares. And corporate finance one venture finance session really is a bit of a deeper dive panel discussion, particularly in the area of dealing with the finance. And on to the next slide. If you have questions for any of us, we'd be delighted to talk to you. Here's the contact information for each of us. Again, Melissa based in Calgary, Manoj based in Toronto, myself based here in Vancouver. You should feel free to reach out to any one of us if you have questions about any of the topics you heard in today's presentation, or if you had a question that we didn't get to, shoot us a note and we'll try to answer your questions in a sidebar conversation. Of course, if you have questions about our Startup and Grow program or any of the resources available in that program, we're delighted to hear from you. Each of us are quite passionate about working with early stages businesses, enjoy those conversations, and would love to have an opportunity to get to know you and your business a little bit better. So with that, subject to any final remarks from Melissa or Manoj, I'll just say thank you very much to Melissa and Manoj for speaking today. Thank you. And thank you to our audience members for taking the time to join us during these unusual times. Thanks for being with us today. We hope we found this useful and informative, and we look forward to seeing you online or in an event in the future. So thanks very much for your time today.
Thank you.
Thank you.